NACDL is the association of the nation's criminal defense bar.
This project is supported by grant number 2019 YABXK001, awarded by the Bureau of Justice Assistance. The Bureau of Justice Assistance is a component of the Department of Justice's Office of Justice Programs, which also includes the Bureau of Justice Statistics, the National Institute of Justice, the Office of Juvenile Justice and Delinquency Prevention, the Office for Victims of Crimes, and the SMART Office. Points of view or opinions in this program are those of the presenters and do not necessarily represent the official position or policies of the U.S. Department of Justice.
Greetings, I'm Valerie Hans, and I'm the Charles F. Recklin Professor of Law at Cornell Law School. I'd like to share with you some information from social science studies about how a defendant's criminal record can affect jury trials. Let me share my screen with you. The rules of evidence in federal and state courts may allow the introduction of criminal record information if the defendant chooses to testify. One common test for admissibility is that the judge will evaluate whether letting in information about the defendant's criminal record is probative, that is, would help the fact finder, or would be prejudicial and bias the fact finder in the decision making. This rule might well discourage defendants from taking the stand and testifying in their own trials because they are worried about the potential biases that might occur. When we think about criminal record and how it might affect judges and juries, there are a number of different possibilities. First, it might affect perceptions of the defendant's credibility. That is, how likely the defendant is to be believed as a witness. This is actually the prime justification for allowing criminal record in if the defendant testifies. That is, the assumption is based on the assumption that somebody with a criminal record is more likely to lie. And so you evaluate their testimony knowing that piece of information. But it could also create what we would call a negative halo effect. That is, learning about the criminal record changes the jury's perception of the defendant himself or herself, making them look like a bad person who's done bad things in the past and is bad generally. It might also have some effects on how the jury interprets evidence in the case. In particular, the meaning of the evidence, the significance of the evidence, the weight of the evidence might change, knowing that the defendant has had a criminal record for committing a crime in the past. And finally, one possibility is knowing that a defendant has a criminal record and has committed a crime previously might lower the burden of proof, lower the threshold for conviction. So when people come to apply the beyond a reasonable doubt standard, they're a little more generous and a little more likely to find the defendant guilty. Social scientists have done research on criminal record and what effects it might have. And I've been studying the effects of defendants' criminal records for many decades. In fact, my very first research project as a graduate student examined how mock juries were influenced by learning about a defendant's criminal record. In the study that I did and in other mock jury studies that examine the effects of criminal record, it goes like this. The mock jurors will hear evidence in a case, prosecution evidence and defense evidence, and the defendant would testify in these cases. And half of the mock jurors learn nothing more about the defendant. The other half actually learn that the defendant has a criminal record. Now, this is usually in the mock jury studies, as it is in real life, accompanied by what are known as limiting instructions. That is, instructions to the jury that they may use the criminal record information to make a judgment about credibility of the defendant Remember, that's the prime justification for allowing it in the first place. But the limiting instruction says that they may not use it to directly infer guilt in the present case. That is, just because this defendant committed a crime in the past doesn't mean this defendant is guilty of the present crime. So depending on the type of research, the mock jurors might reach individual decisions or might join together with others and reach a group decision in the case. And that's what I did in my study. And here are the results. If they look surprising, they were kind of a surprise to me too. I purposely made the case weak, the evidence in the case against the defendant weak, because I want it to be sensitive to the possibility that criminal record could increase guilty verdicts. So the column on the left here shows what happened when the mock juries in my study simply heard the evidence in the case against the defendant. And you see that in every case, the mock juries didn't find that it was adequate to reach a guilty verdict. So none of them wound up convicting the defendant. But the other half of my participants who did hear about a criminal record and that limiting instruction that told them don't infer guilt in the present case, just credibility, you can see that the evidence suddenly seemed much more compelling to this group. And 40% of the juries in this group wound up convicting the defendant. Mine's just one study, and many other research projects have also examined the effect of criminal record and limiting instructions and whether or not the type of criminal record matters. And we've discovered a couple of things. One is that the limiting instructions that judges give to juries when a defendant testifies and the criminal record is made known, these are basically worthless. They simply don't reduce the bias that comes from learning about the fact that a defendant has a criminal record. The other thing that we have discovered is the prime purpose of allowing a criminal record, that is to judge credibility, does not seem to be the way that jurors are using the criminal record information. Instead, what they seem to be doing is making direct inferences of guilt in the current case. So I studied mock juries. Many other of my colleagues studied mock juries. What about real juries? I mean, after all, real juries are holding a real defendant's fate in their hands. And they have a solemn responsibility. And juries generally, I know from other research that I've done, generally do a good job and definitely try to do a good job. Does criminal record have similar kinds of effects in the real world with real juries? Well, I was able to draw on a research project conducted with collaborators from the National Center for State Courts that I participated in along with several other scholars. And what we did was to send questionnaires to judges and jurors and lawyers too in 4 jurisdictions across the United States. And we asked them a number of questions, including whether or not the defendant testified, whether or not the defendant had a criminal record, whether that criminal record was made known to the jury, and what the outcome was in the case. We also asked a variety of other questions, including how strong the evidence was in the case. And those all turned out to be valuable in trying to understand the effect of a defendant's criminal record. My late Cornell Law School colleague, Ted Eisenberg, and I collaborated on a research project using these data from the 4 different jurisdictions to study the effects of criminal record. So it was really important to have all these pieces of information so that we could examine exactly these questions about impact on the trial and on the jury. One thing is that we discovered that the kind of assumption that defendants might be reluctant to testify if they had a criminal record was borne out by the research. You can see here that defendants are more likely to testify if they don't have a criminal record, and ones with a criminal record less likely to testify. And that's significant, statistically significant. This is really unfortunate because defendant testimony is one of the most important pieces of evidence that could be presented at a trial. Juries want to hear from the defendant. When they don't hear from the defendant, they wonder why. It seems like the fear of bias here is preventing many defendants from testifying. My Cornell Law School colleague, John Bloom, examined a group of exonerated defendants and found 91% of them had criminal records and yet had not testified. Now, that absence might well have eventually contributed to their erroneous convictions. Again, what they would have said and how they would have explained themselves was just absent from the record, and juries convicted individuals who wound up being later determined to be factually not guilty. Now, one of the interesting things that Ted Eisenberg and I discovered is that it was usually the case, often the case, that when a defendant testified, the criminal record was made known. About half, a little over half of the defendants who testified wound up having their criminal records made known to the jury. Remember, a common test is that judges can sometimes prohibit that information if they fear that it's going to be too prejudicial for the decision makers. But one of the interesting things is 9% of the defendants who didn't testify at all wound up having their criminal records made known to the jury. So the question is, when juries learn about criminal record, whether it's through defendants themselves who testify or in the other cases where they don't have they don't see the defendant testify, what happens? What Ted Eisenberg and I found was that the effect of criminal record was quite pronounced in weak cases, cases with evidence that, like in my mock jury study, normally would not be producing convictions. What you see here on this graph are two sets of bars. The left set of bars includes cases where the judge and jury thought the evidence overall was not particularly strong. And here's where criminal record has a major impact. 18% of the defendants in these low evidence strength case are convicted if the jury doesn't learn about the criminal record. But when they learn about the criminal record, it jumps to close to 43% of the cases. The right-hand bar shows what happens in cases where there is strong evidence. Here, you don't see much of an effect at all, certainly not a statistically significant effect of learning about the defendant's criminal record. When prosecution evidence is strong, the jury is going to convict. It doesn't matter whether they have a criminal record or not a criminal record. So we got to be most concerned about cases where you have relatively modest evidence, modest to weak evidence. Those are the kinds of cases where it could be most detrimental to the defendant, most biasing to the defendant, to have the criminal record revealed. So I'll conclude with just a few points. One is the fact that defendants with criminal records are reluctant to testify is really quite concerning. It does deprive the jury from hearing their story, from learning the defendant's perspective on the cases and the kinds of evidence the defendant can provide, perhaps uniquely. And this knowledge of criminal record appears to promote conviction in close cases that otherwise would not lead a jury to convict. That, of course, raises the worrisome probability that jury knowledge in these weak evidence cases about criminal record might lead to erroneous convictions, as my colleague John Bloom discovered. All of this suggests that we should look carefully at changing the rules that allow the presentation of a defendant's criminal record, the admissibility of a defendant's criminal record when the defendant testifies, so we can avoid these negative consequences. If you'd like to learn more about the research underlying my presentation, here's a link in the slides. Thank you.